Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friend Bruce from Oregon. I asked him to help me out with this because obviously after the filing by Blake Lively's attorney came out on Friday, I was feeling a little confused and irritated. And so I needed the Logic Moose to come in and help me out. As you can see, he's in his van, so the picture and sound might be a little bit off, but he's still here with us, so that's cool.
I'm doing my best.
Yeah. No, I went to pull up this stream, and you guys know I'm always late, but at the same time, I was like, why are there 400 people waiting for this right now? This is crazy. Anyways, I wanted to start out by saying, because some people were confused about this, so let me pull this up really quick. This is the notice that I filed last week, and I'm not going to read it because I've decided that I don't want to read my own court documents. I feel like that's a little, I don't know, it makes me feel just like, I don't know, I want to cringe at myself a lot, so I'm not going to do that.
I think you have to do it. It's part of the penance. You got to do it.
No, what I'm actually going to do is let Snitzel Ninja do it whenever I do this, because
great.
That way, since I'm not crowdfunding, I figured maybe she could, use the funds for Mike or something.
That would be great.
I just wanted to show this memo. So the motion to quash shall be filed by July 28th, with responses due no later than August 4th. So I didn't actually file a motion to quash. This letter was just to let the judge know this is what I intend to do. This is why, please help me, basically. Because we had that whole issue with the dates, where the date on the subpoena to Google said that documents should be produced by July 16th. And Google still, a week later and long after that deadline, has not answered me to clear that up, because they also said by July 31st, you need to submit evidence of a motion to quash. And so I decided just to do this and just to get that on the record and see what they said. And so he said I have until Monday to file that, and then we'll go from there. So yeah, like I said, I'm not going to read this letter, but it's up on the docket if anybody wants to, but I have not done anything as far as an actual motion yet. So that is yet to come. And it's going to take a lot longer than this letter did, so I'm glad I have time this week. All right. Let me pull up. We're going to start here with what happened on Friday, because I was, again, out of town, even though I wasn't expecting to be, so I didn't have time to really stream or anything this weekend. I've had people in my email inbox and everything being like, Lauren, you're not going away now, are you? Just because I'm like, no, dude, I'm just busy. I'm just busy. When have I ever been
jet setting around the world? It's fine.
Yeah, it's no big deal. All right, so this is the filing I had Bruce read for me. And he actually put out a video, which I watched last night. And this was what Blake's attorney put out, which was suggesting that the reason the content creators were subpoenaed was because they were named in discovery by TAG, which is the agency group, Melissa Nathan's PR agency. They worked for Wayfair and Justin Baldoni. I think they were signed back in August. Maybe it was before that. I'm not sure. But I didn't start covering this case until January of this year. So, you guys do the math with that one. I don't know. But anyways, I was a little concerned when I read that. And I know a lot of us kind of went, maybe we are on a list, because PR teams, they do put together lists of like news outlets, media outlets, content creators, anything that's like positive, neutral, negative. So they have like lists of accounts, people, reporters, stuff like that. So we were like, maybe that's it. I don't know, but they're still misrepresenting what's going on here. So when I asked you to read this and you went over it, I know you like took notes and you did like a whole breakdown, but what was your initial impression overall of this?
Oh my gosh. I thought, well, we should probably go through it a little bit.
Yeah, sure.
I didn't read through this whole document for my video. Okay. For my video, I mostly focused on the subpoenas.
Yeah, because I sent you the whole subpoena, right? Okay, so
my original problem was I don't even understand why these subpoenas are happening. Like if your goal
that's
in
the
life,
thing.
yeah. If your goal in life is to find some sort of evidence of a smear campaign that was orchestrated by Wayfair or TAG, where they paid or coerced content creators into doing something,
right?
How does this subpoena accomplish it? And that's sort of what my video went over.
Yeah.
This document is very interesting. I've listened to a lot of people read through it.
Yeah.
And they point out a lot of the things, which I think you're aware of, that don't make sense in this document.
Right.
And if you want to go through those, we can do that.
All right, hang on. We'll start. It's not a very long one, so we'll start here. Let's see. The interrogatory responses, which is the discovery that they're talking about, identify individuals and media outlets with whom TAG communicated about Miss Lively and topics related to this lawsuit. This information does not constitute trade secrets under the party's protective order, as TAG claims, and the designations are thus improper. The court should not permit TAG to manipulate the discovery process to perpetuate the same harms that got it sued in the first place. So they're saying they're like hiding this information improperly. But the whole thing with the attorney's eyes only provision, like in the beginning of this case, when they talked about the court's protective order, was that the PR teams, like this was important for the PR teams to keep their client lists and stuff away from the public. Like that was going to hurt their business. And so that was what like Blake's publicist and all those guys were talking about. They're like, this is important. And so now they're saying that they're manipulating the system somehow by trying to keep that private. Of course, we know a lot more now than we did when they wrote this letter, but that was the first thing that stood out to me. I was like, okay, well, you guys were the ones who wanted this whole AEO thing. But okay.
One question I have is, are there sort of two lists here that they're talking about? Because at the start, they're complaining about this list where TAG communicated about Ms. Lively with individuals and media outlets.
Right.
So that's sort of a communication list, right?
Yeah.
Whereas I think further on, somewhere they start to talk about how they want to subpoena the people who, what was the word? Apparently communicated with TAG. So I'm wondering, like you said, these groups are going to have a group like TAG. They're going to have lists of people covering a story so they can keep their pulse on, do we have positive feedback, neutral, negative feedback, all of this. So there's probably a list of people they're watching, and there might be a different list of people they're actually communicating with. And understanding the difference between those two is very important. Also, what is the definition of communicated? Because if I go to your video and I hit the like button, have I just communicated with you? I don't know. That's a little, that's not the same as sending a bunch of emails back and forth.
No, definitely not. So it is like, it's like one set of interrogatories, I think, but is asking multiple questions. And so they're referring to this, I believe they're referring to the same document. But they're like kind of conflating these things when it's actually two separate questions. So that was a little off. Okay. Oh, Laura, my email is, it's LACKURATE. So lackurate, like lackurate, LACKURATE. Yep. Hey, Omar, what's going on? All right.
Don't forget the K.
Yeah. Right. Okay. A core component of Miss Lively's claims centers on the defendants and cross-complainants Wayfarer Studios. Okay, I'm not going to read all that. Blah, blah, blah. Digital media smear campaign, which sought to manipulate the media landscape using untraceable sources to paint Miss Lively as the aggressor instead of the victim. So right there, I have a comment. So they're saying that this untraceable smear campaign and its sources were the problem here, but like she somehow knows each time that she kind of goes around people's, rights to object to the fishing expedition she's doing, somehow knows exactly who to subpoena or exactly what to look for every time. She knows exactly what she's looking for. So how is that untraceable?
Yeah, if this is untraceable, what is the utility or what is the point of these subpoenas? It doesn't make sense, right? Yeah. If the subpoenas make sense, or if they're going to go try and figure out the evidence or the proof of this smear campaign, then it isn't untraceable.
Right.
So it's very strange wording here for me.
Yeah, and I mean, like, think back to, I don't know how much you know about the Van Zandt and how they got their hands on all the evidence for their complaint in the first place. I don't know if you've heard anything about that. Yeah, so they went and did the John Doe thing, but they knew exactly who they were talking about then too. So this whole time, there was never been a question, and yet she's claiming there's some sort of invisible smear campaign against her.
That one was really wild. I think Omar coined it the evidence laundering.
Yeah, that was it.
And that was a good terminology for that, because it's really very strange. It's like, okay, let's do this thing over here. That gives us the ability to do another action over here. Then we shut the first thing down. That's really disingenuous, right? And we don't want to have a precedent where people can just do that sort of thing.
No,
or things like this, where it's like, oh, we've got an untraceable smear campaign. Let's issue subpoenas all over the place. Really?
Seriously, everywhere. Yeah, it's crazy. All right. Seemingly unable to abandon this playbook, Tag's interrogatory responses yet again attempt to bend reality to the Wayfarer party's ends. It's weird. Like that doesn't even like what language are you speaking right now? Like that stuff doesn't even that sentence doesn't even make sense in context of what you're saying right now. Like what do? They kept their, list of people they've been in contact with private, like the publicist agreed they would do in the beginning of this case. So why is that bending reality?
Yeah, you got to watch out for things. The things I always watch out for when I'm reading these documents, there's two things. I always look for these excessive adjectives or adverbs, like especially words that end in ly. Amazingly great, or whatever the extra adjectives that don't need to be there, because
apparently
yeah,
seemingly
someone is trying to focus their language in a certain way, either to bolster their argument up or to give them an out, like the apparently, right? The second thing is things like this, where it's very rhetorical, or a lot of sort of rhetoric, like we're going to bend reality to their ends. You see, we saw a lot of this rhetorical, inflammatory language used in like the Gingras filings in the Owens v. Eckert case.
Yeah.
And there's more of it in here too. I think in the footnote, for example, they start talking about, Darvo, and it's like, are you going to, do both sides that are arguing in a court case just sort of, can they both claim that the other side is doing Darvo? Like, we need real evidence. You can't just make a claim without evidence.
But they've been doing that left and right, dude. It's crazy. And like the footnotes here are probably the worst part of this filing to me. These footnotes on this page. Like, so Ms. Lively brings this letter motion pursuant to the protective order. Let's see, court's individual bracket, blah, blah, blah. As Amici in this case have noted, and there were all those amicus briefs back then when I was like, this is highly inappropriate. All these people are accusing these people of being guilty already. And I really hated what they were doing. But as Amici in this case have noted, the Wayfarer defendants have employed tactics frequently relied upon individuals accused of sexual misconduct to recast the abused as the abuser. It's fucked up that they can write that in here. And it's fucked up that these organizations who are supposed to stand up for real victims of domestic violence and sexual abuse and sexual harassment would insert themselves into this docket, paint these men as already guilty, these men and their families, their wives who are also, involved in all this, as already guilty of what Blake Lively's accusing them of. And now to see that cited over and over again is infuriating. So I really hated that more than anything else. I think it's such a disappointment that these organizations stuck their neck out for her. And they did it because she has money, in my opinion, because she has money and influence, and she could get people to do that for her. Like, look at how the media is not even covering this subpoena stuff right now. They're quiet because she's the one with the money. She's the one with the influence. And the fact that these organizations sold out to her in the middle of this with no evidence that these men or women were guilty whatsoever is disgusting. So,
yeah, the approach I try to take is, if somebody's making a claim like this, like, hey, the other side is exhibiting Darvo, the way I would diagnose that is I would say, first, you need a foundation of somebody. You have to actually prove that somebody is an abuser. And once you've done that, then you can look at their behavior and say, is this consistent with Darvo? You can't just take a claim you haven't established yet and make a secondary diagnosis like Darvo about it. That doesn't make sense to me, or at least it hasn't been established yet.
Yeah, it's so messed up, dude. All right, let's see. I don't want to read this word for word, but let's see. So she was asking Tag about content creators they communicated with. Okay, number 5 asked, identify all content creators with whom you've communicated in any manner concerning to Miss Lively, Mr. Reynolds, the CRD, the actions, blah, blah, blah. On June 18th, Miss Lively propounded similar interrogatories on Heath, Baldoni, It Ends With Us, the rest of the Wayfarer parties, basically. And those responses are due on July 18th, so that was like a few days ago. The day this letter, I think, was submitted. Okay. After Tag was ordered to respond to the interrogatories, which includes the content creator questions that they just mentioned in the paragraph above, Tag supplemented its responses, identifying a number of individuals who have spoken publicly about Miss Lively in this lawsuit, apparently at the behest of Tag and the other Wayfarer defendants. So this is where they kind of got got people, right? So what did
Now,
when you saw that, like, where
to me,
where
it's
did you
like
go?
we've got two lists now, because the first list was, hey, who did you communicate with? And I think that itself is broad, because it's like, it's not like, hey, who did you pay or who did you contract with to do work, right? It's just communication. Anybody can communicate, can send an email to anyone, right? So there's that first list, but now what we've got is this. What did they say? It was a supplemental addendum or something, supplemented the response. Identifying individuals who have spoken publicly. So that could be anybody on Twitter, TikTok, YouTube, anywhere, without ever talking to Tag or Wayfarer. So now we've snuck in two lists.
Yeah. Right. And so I just want to mention also, for a lot of people who were worried about this over the last week or so, Stephanie Jones, who's on kind of like the outside of this with the publicist lawsuit, she sent subpoenas to Pinterest and to Meta, so which is like Instagram and Facebook, and she got shot down so hard. And so I'm wondering if if Blake even bothered to subpoena Pinterest and Meta. But the thing is, like, people were worried that she would subpoena Reddit, which I think is a reasonable concern at this point. But if she were to subpoena Reddit, I already know how that would go. And I know how that would go because we've been through that before with David and with the Redditor. So last year, we had a friend who was, we had this dickhead attorney in another case that we're following. He's an absolute moron. Probably the worst lawyer
Owens
ever.
Vickard case. Right.
Yep. And he didn't like that this Redditor was doing recaps of his videos on Reddit. Like, just taking notes, basically. Taking notes and putting them out. And so he
Notes
tried to
and commentary. Notes and commentary.
And so he tried to subpoena the Redditor, or he tried to subpoena Reddit for the Redditor's identity, her personal information, contact, whatever. And Reddit basically told him to go fuck himself. So while all of these other platforms, Twitter, TikTok, Google, have not done a great job here, Reddit is probably the one you definitely don't have to worry about, because I've seen how they operate, and they're not just gonna roll over on that. Absolutely not. So Redditors, you can calm down a little bit. It's all good.
What's going on in Pinterest? Like, what do you do on Pinterest? Like, find a couch that matches Blake Lively's wardrobe or something?
I didn't know anyone still used Pinterest. I didn't know it was still a thing. And then I was like, oh, of course Stephanie Jones is subpoenaing fucking Pinterest. I don't know, man. I guess somebody said something bad about her on there, and so she was like, well, we have to drag them into court now.
Wow.
That's pretty much how these ladies operate, I guess. God. Anyways, despite the factual nature of this information, Tag unilaterally designated its responses as confidential and attorney's eyes only, obscuring Tag as the source of this information and allowing the Wayfarer defendants to once again recast Miss Lively as the aggressor in pursuing subsequent discovery. So this is really important to remember right here. So 1, they're saying Tag unilaterally designated its responses as confidential AEO. And 2, they're saying this is what obscured them as the source of the content creators, like the information on the content creators who were therefore subpoenaed. Okay, because we're gonna see that that's not necessarily the case here, but I just wanted to make sure we went all through all this and tracked it, and like we can put up point by point.
So what is the big problem of that information being attorney's eyes only? I mean, they make this big argument that it frames Blake Lively as the aggressor, right? But when you're doing discovery, you're asking for things like that's just normal. Nobody's, I don't know. You're not an aggressor. You're just, you're doing discovery in a court case. It's not.
This is my understanding is, so I have tried to talk to these attorneys, and I'm representing myself, so I have to speak to them directly. They will very infrequently respond. Often takes a very long time. It's been a while now. I haven't heard from them since last week. And when this filing came out, it made it sound like because Tag designated that list of content creators, attorney's eyes only, they couldn't disclose that. So they're saying basically like, we can't answer questions and properly meet and confer with these people because we can't tell them that the reason we're doing this is because they're on this attorney's eyes only list. If that makes sense.
Good golly. The attorneys can share that information with each other, right?
I don't know, actually. I think they can. They can talk to each other about it, but I'm not an attorney, right? And so, like, I think they're saying, like, the party's attorneys only is what they were getting at. That's my understanding of it. I could be wrong because I'm not an attorney, and I know that, you know that, they know that, which is, why they don't answer my emails, even though they have to.
Yeah. I mean, in the Owens Viecker case, it would sort of be like if you had, Corey Keith on one side and Greg Woodnick on the other side, maybe they could meet and look at some medical data that had been classified as attorney's eyes only, and they could look at it together potentially, right?
Yeah.
After the February hearing there. But maybe that's what's going on here. And they seem to be casting it in a very disparaging light, which again, I don't know. It's just discovery.
Omar says, of course they can.
Yeah,
Omar, you come tell us yourself, man.
Yeah,
I gave you the link.
I need Omar, but
someone who knows what they're talking about.
I mean, I'm just using common sense and what I know from prior cases. So I'm not a lawyer.
And I'm just using pure unfiltered rage. All right. Anyways. No, I'm not angry. I'm in a weird spot right now. I feel like chill because of all the way this all turned out, but at the same time I have a lot to do and I'm stressed out about that. So
we're gonna channel your rage, Lauren. It's gonna be all right.
I don't know if I'm rage filled tonight. I feel like it's gonna be coming on soon, later this week maybe, but
when it's there, we'll harvest it.
Yeah. Anyways, let's see. Okay, while trade secrets can be designated as confidential, we don't need to know that. These misdesignations are having very real impacts. For example, if Ms. Lively issues subpoenas related to individuals identified in TAG's interrogatory responses to marshal evidence about their involvement in the smear campaign, she will be hindered in her ability to meet and confer or respond to questions, which is what I was just saying, and will be unable to explain to such subpoenaed parties that the discovery directed towards them is based in part on the fact that TAG identified them. So yeah, that's exactly what I was just saying. Content creators who have been the subject of discovery have already painted Miss Lively as the aggressor in this lawsuit, and she very much is. Let's not make a mistake.
So is their argument then like, hey, we want to be able to tell Lauren what's going on, but we can't because this information is just for our attorneys and their attorneys?
That's my understanding of what they're saying here, yes.
Okay, all right.
So, but that's BS, and we're gonna find that out soon. So, let's see. I
mean, I still don't understand what they're trying to get out of these subpoenas in the first place.
So we'll get to that. We'll get to that because I have my own thoughts about that. But one subpoenaed content creator even went so far as to record a call with a receptionist from Ms. Lively's attorney's office without express consent, and then posted the recording to YouTube. And then they're citing a video here from Andy Signor, the guy that Popcorn Planet guy that I went and I did his documentary filming last week. They cite his video here, but I don't think that they actually include the call in here, because if they do, then we can see pretty clearly.
Well, it doesn't have a timestamp, unfortunately.
No, it doesn't. We got a transcript though. Hang on.
My understanding, I've seen some other videos on this. My understanding is that he said, "Hey, I'm recording this,"
So so I don't know if this is the correct video, which is why that was also annoying. Because I'm looking at it right now, but you can't see it on the screen.
Yeah.
I'm close it because
so
it's not the right
if
video.
you inform the person you call and they don't hang up, I mean, even if you're in a two-party consent state, which I'm sure,
Correct.
I think he probably is.
California and Florida, I believe. Yeah. Right.
Yeah. So that's the proper procedure, right? You inform the person, and then if they don't want to talk to you, they don't have to talk to you. If they want to hang up, they can hang up. Otherwise, they're going to be recorded. I mean, it's funny because they don't say why this is a problem. They use this very strange language here that I can't wrap my brain around, saying drawing a false equivalency. A false equivalency is basically like saying two things that aren't the same or the same. Therefore, if you can draw a conclusion about A, you can draw a conclusion about B because A and B are the same. And then the fallacy is if A and B are not the same, you can't draw the same conclusion. Okay. Between discovery efforts and the Wayfarer Party's alleged smear campaign. I mean, I don't know who's trying to do that. I mean, I think most people are saying they don't believe that the Wayfarer Parties even did a smear campaign. And I think most people are saying, but on the other hand, most people are saying we're in discovery. So I don't know what the false equivalency here is. It's not very well explained logically.
Right.
Maybe somebody, I don't know, maybe somebody else or someone in chat understands.
Somebody pointed out here, he informs her twice that he's recording and asks her if she's comfortable to talk. And then she proceeds. So, I don't know. Sounds like she knew to me. And I also watched that video, so I'm aware of what happened. And that is my understanding of the situation, too. He did say, I'm on a recorded line. I want this on the record. So,
sure.
Yeah. Okay. And then
so I don't know why they're putting it in here because it's fine. Like, what's the problem?
They're just trying to like shift the blame onto content creators and be like, look, these people are scum or whatever. And basically say like they're like blaming her for no reason. It's not her fault. It's Tag's fault. It's the Wayfair party's fault, but it's not. And we're gonna see that very shortly.
Yeah.
But,
this is the other. And remember the red flag I pointed out earlier with the ly words? So they say, or the extra adjectives. They say the content creator used the recording to make false inflammatory remarks. Like, ooh, inflammatory. It's like, oh, scary. But my problem with this is, and this is another thing we saw in the Owens v. Eckerd case. If you say somebody made false remarks, you need to actually prove what those false remarks are. You need a URL, a timestamp, the false statement, and then the evidence that proves that that statement is false.
Yeah.
And they didn't seem to do that here. So it says CID, but I mean, they're just talking about the URL or?
I guess so, yeah.
I mean, that's insufficient because it doesn't prove a false statement. It's just an accusation of a false statement. So that's disappointing. And
then they were saying that he was seeking to fundraise based on the recording in his remarks, but that's not true because he was subpoenaed personally for his like communications and documentary footage, to my knowledge, the week before, a week or two before. And that's when he started fundraising. He was like, I need help with attorney's fees. So it had nothing to do with this. So they're making it sound like he's trying to make money off of what they're doing right here. And that's absolutely false. So, all right. The bottom line is that the concern about being hamstrung in being able to tie her discovery to the Wayfair party's discovery responses further exacerbates public backlash against Miss Lively, which she should not have to endure when there is no conceivable privacy interest that Tag and others are protecting. And again, we're going to see the response in just a minute here, but the public backlash against Miss Lively is very much, at least in my case, because she's seeking my fucking bank information. For what? For what? What does she want my bank account and credit card numbers for? What does she want blockchain data and IP addresses for? What does she need all my, email addresses and backup and recovery email addresses for? How is that going to help your litigation? Tell me how that's relevant. And these lawyers still cannot answer my fucking question.
Yeah, because if the attorney's eyes only information you're trying to protect is really people's identities, right? You can prove if there really is a smear campaign. If some corpo paid you $1,000 to make a video and they have evidence of that, they don't have to include all the names in it, right?
Right. Yeah.
They can demonstrate proof of their claims without violating anybody's privacy.
Yeah.
But we haven't seen anything like that, have we?
There isn't any. There's none.
Yeah. I mean,
and that's why she's like, I got to dig to the center of the earth through these people, the random public, content creators' accounts to try to find something, anything I can pin on these people because I have nothing.
So I think, the problem is if they want to convince me with this kind of letter, they need to be way more specific and have more context because just these sort of vague, generalized arguments or these inflammatory statements are insufficient. They're not good enough. I need context and details, and you don't have to dox anyone or put business, plans out there or something like that. You can find very targeted information. Hey, here's a bank transfer made from Tag to person XYZ. We want to see if these two account numbers match. Right. I don't know. Right. But I haven't seen any of that detective work yet.
Nope. No. All right. They're talking about history is repeating itself with the untraceable campaign, even though we absolutely know who the parties involved here and the non-parties involved are. So what the fuck are you talking about? So they were asking. So Ms. Lively asked the court to make Tag de-designate its interrogatory responses so they won't be confidential anymore. And that's what they were asking for. And so now we're going to see the response to that. Just give me 1 second, which came out today. And have you read this yet, Bruce?
I have not.
Okay, so we're gonna go through the whole thing, and you point
Mhm.
out to me like what you notice. All right.
I think the last thing I saw was the judge had said that you guys could file motions to quash
Oh yeah,
either
yeah,
with your own name or anonymously in
yeah.
conjunction with a motion for anonymity. I think that's the
Right.
last thing I saw, which looks like
Yeah.
good news.
Mm-hmm. Okay, so they're writing in response to the motion to compel TAG to de-designate the confidential AEO designation. All right. According to the motion, a core component of Lively's claims is that the Wayfarer parties are engaging in a smear campaign to somehow manipulate the, and then he says apparently, just to be sarcastic there, worldwide media landscape using untraceable sources to portray her as the wrongdoer. Characterizing the so-called campaign as untraceable not only defies common sense, given that Lively knows precisely which news articles or stories and the authors thereof she takes issue with, but also undermines any justification for her ongoing effort to use this court and the federal rules of civil procedure to discover the untraceable. Okay. In any event, Lively contends that TAG may have been able to obscure its contacts in connection with the initial smear campaign. In August 2024, which you know, Bruce, because you covered the beginning of this with me, was 4 or 5 months before I ever touched this shit.
Oh, yeah.
That is an admission that, despite months of discovery, her receipt of thousands of pages of documents and her service of dozens of subpoenas and other requests for written discovery, Lively has no evidence that the Wayfarer parties employed a smear campaign or did anything in August 2024 other than protect their reputations, as they are entitled to do when Lively's allegations were publicized. All right. Indeed, TAG was not retained until early August 2024, rendering Lively's claim that in less than 2 weeks, TAG was able to turn the public against her incredible.
Oh,
That's,
my.
yeah. Unable to accept the fact that the public backlash against Lively was purely organic, the motion improperly seeks to blame TAG for Lively's sinking reputation. Without citation to any evidence, the motion alleges that the individuals identified in the interrogatory responses have spoken publicly about Miss Lively in this lawsuit, apparently at the behest of TAG and the other Wayfarer defendants. However, the motion ignores the broad scope of the interrogatories, and here's where we get into what it actually asked for,
Exactly. Yeah.
which seeks the names of those with whom TAG has merely communicated concerning, among other topics, Lively, her allegations, or this lawsuit, from May 2024 through the present. That is why the interrogatory responses identify those to whom TAG has harmlessly provided quotes from the Wayfarer Party's counsel in response to media requests for formal statements in connection with legal developments herein, as Lively's legal team has repeatedly done. Both legal teams are doing that. So they're saying they're identifying people that they've given formal media statements to through the attorneys, which is exactly what Blake's counsel has done.
Yeah, and we've seen attorneys do interviews and things like that, which is fine.
The interrogatory
I think the nice thing about this
go
filing is that they go through the very specific dates. Because I think the timeline is very important in this case, especially in the early days of this case. Laying out the timeline is very important.
Right. Let's see. That is why the interrogatory responses identify those to whom TAG has harmlessly provided quotes. We went through that. The responses are in no fashion an admission that TAG communicated with the individuals to tarnish Lively's reputation, as she falsely alleges. Lively will not uncover any nefarious efforts by the Wayfarer parties to convince anyone that she is anything or nothing at all. In fact, TAG did not... Okay, oh my God. TAG did not communicate with any content creators about this matter or the underlying allegations until 2025, when requests for comments were proffered. What, is it proffered or preferred?
Proffered.
Proffered. Okay. Yeah.
Mm-hmm.
So yeah, basically they're saying they didn't communicate with any of these content creators anyways until after the lawsuits were done and people were asking for comment. And also, that's all they were doing, is communicating with people who apparently asked for comment. It's not like she was painting it out to be something much more nefarious than that. So.
Yeah, I mean, they would have to show evidence of something more nefarious or some sort of paid campaign. I don't know. I haven't seen anything. I mean, I just know folks like Dave Neal said, "Hey, Brian Friedman, if you want to have an interview, let's do it."
Yeah,
It's
right,
pretty
exactly.
harmless, right?
Yeah. Yep. All right, let's see. The motion contends that the interrogatory responses, confidentiality, and AEO designations are having very real impacts in the form of content creators who are the subject of discovery, aka me and everyone else involved in this, have already painted Miss Lively as the aggressor in this lawsuit. I was doing that long before now. And have drawn a false equivalency between her discovery efforts and the Wayfarer Party's alleged smear campaign. I think fucking not. That is a long-winded manner of saying that Lively blames Tag for the recent public backlash against her. However, that allegation is baseless. Okay. First, if the interrogatory responses are currently reviewable only by counsel, they cannot affect the public's perception of Lively. Second, the recent public backlash was seemingly triggered by subpoenas that Lively's counsel served upon Google, DBA YouTube, TikTok, and X, formerly known as Twitter, collectively known as the social media subpoenas, seeking all account information, including phone number and financial information of specific content creators. According to one article, if Blake Lively had been hoping to garner public sympathy in her ongoing sexual harassment lawsuit with Justin Baldoni, that now seems unlikely given the backlash over her subpoena to Google for her information about several pro-Justin Baldoni YouTubers. Third, of the various content creators and members of the mainstream media identified in the responses, only one of them is the subject of the social media subpoenas. So only one person who has been subpoenaed, and one of us, now 43 people that we know of, because there's TikTok too. One of the 43 was also listed in those disclosures by Tag as somebody who may have reached out for comment.
Now, was that the first list or the second list?
So it was like one like set of interrogatories, right? And then one was like, what was the second list again? One was like just people they communicated with. The second was what? I forgot.
Anybody talking about the case.
Okay, so it was one of those. One person, one of the 43 of us was on one of those lists. And they made it sound like we were all being paid or at least posting at the behest of Justin Baldoni's PR team.
Really? Only one?
Yeah.
And we don't even know if that was the original list or the modified list.
Nope.
Because it's unclear here.
Right.
They need to spell that out because that's important, I think. Well, I mean, it's not. It's Omar would say it's a nothing burger in either case, but I'm always wanting to know exactly what happened on that one. This is kind of wild.
Yeah, no, it is crazy. I read this earlier today. I was like, wow. Like, obviously, I know I'm not going to belong on some list because I'm like, I haven't communicated with these people at all. But okay. All right, let's see. Therefore, the interrogatory responses and the designations thereof as confidential and AEO are irrelevant to the public relations mess that Lively has brought upon herself. Had Lively's counsel properly engaged in and continued the meet and confer process concerning the interrogatory responses, instead of filing the motion in a misguided effort to blame the Wayfarer parties for her public relations woes, a response of this nature would not have been necessary. Tellingly, the motion lacks citation to legal authority supporting the de-designation of the proprietary information contained within the interrogatory responses. The reason for that omission is clear. The motion was filed for a single purpose: to wrongfully foist upon Tag and the other Wayfarer parties the culpability for the criticism she's faced for her social media subpoenas.
Hey, that's a really good point. You know, when we read the previous document, I don't remember a lot of case law citation in it, if any.
Right. No, there wasn't. There wasn't.
And, you know, after we've been through the Owens v. Eckert case, where Mr. Gingras, for all his crazy filings that he did,
yeah, right,
he was at least a fan of backing up his arguments with case citation, even if the cases he cited weren't very good at making his point. He at least
even if he didn't
cited
read them.
cases. And we didn't see that in the previous document, and that's something I missed before. So that's very interesting.
Yeah. So he says Lauren should help Perez out in his response as he seems over his head a bit. I haven't talked to Perez today, but I'm going to email him after this. I talked to him yesterday, so I'm going to email him after this. All right. So here's the best part of this, I think. Tag Tag covets the proprietary nature of the identities of its media contacts. However, Tag is dedicated to standing with the other Wayfarer parties to discredit Lively's false allegations of an orchestrated smear campaign. Accordingly, Tag does not oppose the motion and agrees to remove the confidentiality and AEO designations from its interrogatory responses. In return, Tag trusts that Lively will no longer allege that anything regarding the so-called campaign is untraceable.
Oh, damn. The gauntlet's thrown down. So what does this mean? There's going to be a subsequent... so a judge has to rule on this, and then they would file... They would what? They would make another... these interrogatory responses available on the docket? Is that what would happen?
So... so what happens now is like... Sorry, I was reading the Perez comments in the chat.
Oh, yeah.
But Perez actually stopped into the live stream last time I was on one. But anyways,
great.
So they're saying that they don't oppose this motion, so the judge has no reason not to grant it, really. So they should just unseal it. And at that point, it's not something that's just going to randomly show up on the docket, but if they want to cite it, if they want to show it at some point, for some reason, they can. They can talk about it. It's no longer an attorney's eyes only thing.
So it won't just be blasted out by default if the judge approves this.
No, they would have to...
they would have to use it in some fashion.
Right.
Yeah, that makes sense.
Yeah,
and
I'm sure it'll come out.
It's theoretically possible the judge could deny all this, and like even if both lawyers agree on something, I've seen cases where judges have disagreed with both lawyers. It's rare, but I think it's theoretically possible. But I don't think that'll happen in this case.
No, probably not. No, because they're saying like, listen, we're agreeing to this being out there because it's important to the case that she no longer uses this information to basically falsely allege that we're doing an untraceable smear campaign. So I don't see why he would deny it, but let's see. There's a declaration here, which is it's mostly saying more of the same, but we'll skim over this a little bit. For Kevin Fritz, the attorney for Wayfair.
I'm trying to figure out how to make it untraceable. You got to go out and like dust all the footprints off your driveway every morning or something. Like, I don't know.
I guess, man.
Surround your house with salt, like a line of salt or something. I don't know. What would you do to make that thing untraceable?
Right. Okay. Let's see. So this is, how they said Tag unilaterally made it AEO. Basically, like they just did that without asking anybody or about talking about it. Their interrogatory responses. Yeah, so you remember that from the first filing. They represented that as like Tag said it was attorney's eyes only, and that was it. What actually happened here? Let's see.
You got the reference document?
Yeah.
Yeah.
This is his declaration, or what do you call it?
459.
Yeah, declaration. Yeah. Okay. So, paragraph 9 of the protective order herein provides any party who objects to any designation of confidentiality may, at any time prior to the trial, serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. Okay. Prior to filing the motion that we read from them that said like the AEO is what's bothering us and that's our problem, Lively's counsel did not serve Tag's counsel with a written notice. Okay. With objections. Instead, on July 1st, Lively's counsel sent an email to Tag's counsel asking if Tag agrees to remove the confidential and AEO designations placed on the interrogatory responses, and if not, to meet and confer about the issue. On July 2nd, the next day, I participated in a telephonic meet and confer with Lively's counsel about the responses. During that call, I explained that the identities of the reporters, news or media outlets, and content creators with whom Tag communicated was proprietary to Tag, and the disclosure of which is highly likely to cause a significant competitive, business, or commercial or financial injury to Tag, and that such information constituted trade secrets as contemplated by the protective order. Lively's counsel did not dispute the foregoing. Okay. During that telephone call, Lively's counsel did not explain for what purpose Lively intended to use the interrogatory responses or why she needed them to be de-designated. The next day,
interesting.
Yeah. The next day, on July 3rd, Lively's counsel provided the Wayfarer Party's counsel with notice of subpoenas that Lively's counsel intended to, and apparently did, serve upon Google, TikTok, and X. True and correct copies of the social media subpoenas, which I'm not going to read because we've all seen them by now, are attached here too as the exhibits. The interrogatory responses list only a few content creators, The remainder of the identified individuals are affiliated with mainstream media. The social media subpoenas seek all account information, including phone number and financial information for specific content creators, only one of which is listed in the interrogatory responses. In other words, neither TAG nor its owner, Melissa Nathan, nor the interrogatory responses are the reason for the recent public backlash against Miss Lively, the cause of which appears to be the overbreadth of her social media subpoenas.
All right, so, Lauren, are you saying TAG wasn't subscribed to your channel and liking all your videos? I'm a little disappointed in TAG now.
I can't say that for sure, dude. I can't say that for sure. Yeah. It does seem to be the case, though. I mean, I'm a little disappointed, too, but it's what it is.
Yeah, the concept, the sort of intellectual concept here that these guys are arguing about is what in the tech industry would call sort of an opt-in policy versus an opt-out policy, where if you have this thing like, do you want to receive email, right? It's either like you sign up and by default you get the email and then you have to go do something to get out of it. That's opt-out. Or you don't get the email, and if you want the email, you have to go do some special process to get it. That's opt-in. And knowing whether a certain process here is opt-in or opt-out, especially around these confidentiality issues, is very critical for this case. So that's the terminology I like to use for that one.
Yeah, it's this whole thing is just nutters, dude. It's so nutters. Anyways, okay, we'll talk about this some more, but let me read this last one, number 10 here. Regardless of TAG's right to maintain the confidentiality of its proprietary business information, without waiving any rights of the other Wayfair parties and solely to foster the discovery of information that will further demonstrate that there's no orchestrated smear campaign, and that the negative publicity surrounding Lively is purely organic, TAG agrees to remove the confidentiality and AEO designations from its interrogatory responses. Oh, well. All right, then.
Wow. So they're calling the bluff.
Yeah.
Amazing.
And I mean, yesterday when I saw, oh my God. So Justice for Clayton says, is the tag here the same tag who is like Laura Owens' tag? Is a symbolic
that's a good
tag?
point. Yeah, I think they were saying, even if tag doesn't subscribe to your channel, then other tag still probably does.
I don't know. I blocked other tag from commenting a long time ago. So.
Oh, okay.
Yeah.
Oh, too bad.
We had obviously we didn't become friends, but
no.
Oh well.
They were leaving negative comments all over the internet. I did see that.
Oh, really? Oh, recently?
Yeah.
Oh,
no, just back when all that was happening.
Oh, yeah.
Back in the day.
And it was always about Laura too, which is like the most bizarre thing ever, because it's like the way they email. You saw the email that Tag sent me, and that was ridiculous.
Your email, Megan Fox's email.
Yeah. Crazy.
It's hilarious.
Yeah. So, anyways, I saw that and I was a little pissed, but I also felt a little vindicated because it was like, well, obviously I knew I didn't do anything wrong. But yesterday I had put out that like short video, not here, but on Instagram, because if you're following me here, but not on Instagram, sometimes I put like the shorter form stuff only on Instagram. So I said, I don't want you accessing my bank accounts. I don't want you accessing my IP addresses. But if you want to, like Brian Friedman dared Blake Lively to do, if you want to dare me to answer your questions under oath in front of everybody on camera, I will fucking do it. Because they knew, like, there's no way that's going to happen because they know that they're lying. They know that they're bluffing. And technically, you can look at the wording that attorney used and you can say it's not technically lying. They can't technically get in trouble for that. But I'm not a lawyer. I'm not a technical person. I know in my gut that was the wrong thing to do. So fuck you. That was wrong. She knew exactly what she was doing. She's enabling her client, who is an absolute, in my opinion, psycho at this point, to continue this weird brigade on other people's rights. You know what I mean? Like this weird attack on other people's rights.
Yeah, a subpoena to me, and I wish Omar was here, but to me, a subpoena is like step 3 or 4, and they didn't even do step 1, 2, or 3, right? Like that's how I look at it. Like they could have just tried to talk to these people on the list. They could have tried to get an affidavit. Like you're saying, you don't even need to go on a camera, be deposed. You could say, look, just sign an affidavit that all of your videos are your own content and you didn't work for somebody else as part of a PR campaign, and then you're done.
Mm-hmm.
Right. And you don't have to give out IP addresses or bank information or anything about that. Yeah. So, and I get, I know a lot of people want to speculate that this is, everybody, it's sort of this lawfare punishment sort of thing. And it may be true. I'm not big into the speculation. I just want to figure it out. But I think the key is, if you see the process going awry, like this is what Omar does. He looks at the process and says, this makes sense or this doesn't make sense on the docket. And I think that's what you have to do constantly to keep things honest, right? Because they may try to, if you're correct and they're trying to do sketchy things, then the thing that's going to get that back is just sticking to the process. I don't want to give, my opinion's irrelevant. I'm not giving anybody the benefit of the doubt. I'm not making an opinion. I'm just looking at what evidence.
I don't think it's irrelevant. I disagree that your opinion is irrelevant.
I'm just looking at the evidence and I'm saying, what can I learn from it? What can I deduce from it? Right. And so far they haven't convinced me that these subpoenas make any sense. Their filing didn't convince me. Like, it was full of rhetoric and adverbs and other things like that. So, the other side, the respondent side, just stick with the process and use the process to point. And if the what is the Lively team? They are the petitioner. If the petitioner goes off the rails, they're going to drive themselves off the rails and ruin themselves that way. We saw it in the Owens v. Eckerd case with Attorney Gingras. He drove himself right off the rails and
into another DUI.
We didn't have to speculate about him. We didn't have to, do anything outrageous or anything. We just had to follow the rules, do the right thing, and he drove himself off the rails. And if that's what the petitioner in this case wants to do, that's what they'll do.
Mm-hmm. Yeah, that's true. Okay. So, closing thoughts here. I am still, I want to say mad. I mean, I'm right this second. It probably doesn't look like I'm mad right at the second, but just a general feeling when I think about this stuff. I feel mad because I'm like, this person who intentionally misrepresents the truth time and time again, who intentionally and like in a way that can be easily disproven, misrepresents the facts, is championing herself as the voice of women and girls' safety and as some kind of advocate for everyone who's been through something so horrible as sexual harassment in the workplace or sexual abuse or domestic violence. It makes me mad that these are the tactics of the person who's doing that, when you can clearly see that she's not telling the truth, in my opinion. Like, I look at what her attorney said and I look at the facts and, dude, you're not telling the truth. And even a little bit of a lie, when you are such a high profile person that you go out and you're saying, I am going to be the voice for all these women and girls who have this problem, you better not fucking lie about any of it. You better be very honest, even about your mistakes. That's something I can relate to. If she came out and she actually had a legitimate claim of sexual harassment or workplace harassment or something like that, and she actually was totally honest about, like, maybe, this may be uncomfortable, but maybe this, didn't embellish, didn't overreach to call something like a still photo of a home birth pornography, or to call that dance, film scene that we saw to misquote what Justin Baldoni said and to mischaracterize his actions in that scene. If she didn't do that, then maybe I could understand. Maybe I'd be more sympathetic and maybe I'd be more open-minded right now, but I'm not, because this person who wants to be the next face of the Me Too movement for clout is lying about a lot, including me. So I believe that Blake falsely accused Justin. Blake falsely accused Justin because she falsely accused me. And she doesn't even know me. She falsely accused a handful of my friends. She doesn't even know them. They don't even have their real identities online. She's just lying left and right. And she wants to reap the benefits of having been through this like horrible, awful thing. Like it's some sort of badge of honor. It's not. It's a terrible thing to suffer through. It's a terrible thing to live through. It's a terrible thing to continue to live with as a woman who's been abused. And now she is out here making up fantasy stories about what actually happened to her so that she can be the face of those who have been through that and their issues and be a champion for those women. We don't want it. So I'm done with that.
Yeah, I tend to agree. The concepts that resonate with me are sort of this idea of when you're skipping these steps, right? Or you're making all these claims, but they're very disingenuous. It's like stolen valor in a way, right? Like when, people pretend to have more military attributions than they really have or something. She's trying to say, I have all these experiences that happened to me, but when you look at the foundation of the evidence, it's not there. Dave Neal has a good analogy that's like starting on third base and then taking credit for a home run. You didn't put in the work of getting the singles to get to first, second, and then third base. Right. And that's why I think a lot of the public just doesn't find it genuine, right?
Yeah. Well, she treats being a victim of these things like it's some sort of, like I said, a badge of honor, something to uplift your social status. And it's not. It's a tragic, horrible thing that can rip your life apart in a second and continue to do so for years to come, decades to come. Like, I still have problems from my abuser now, and I'm in my 30s, my early 30s, and I was a teenager, a late teenager when that happened. So I resent her for this. I resent her for using this as a means to elevate herself and to punish somebody who was actually good and actually doing good for women, even as a man, Justin Baldoni. And I resent her for accusing me falsely of trying to smear her because I don't appreciate her disingenuous efforts to take over a movement that's actually meant to help people who have been through this. So, yeah. I think I'm out of steam for tonight, guys. I don't know. Warren, she wants you to put on your florals and be a multitudes. God damn it.
Oh, no. We got to go back to Pinterest. Oh, boy.
Not Pinterest, please. Pinterest says florals. Grab your florals and go to Pinterest. Sally C, thank you for the $50 super sticker. I appreciate you. That's awesome.
Oh, wow.
Thank you so much.
Awesome.
Yeah. Mikhailai, thank you for the 5. I'm so late. Can someone give me the Cliff Notes to catch up? Love you, Lauren. I love you too, but I don't have the Cliff Notes. I have the ADHD, so that's all I got. But you can watch this back later if you want.
Well, Lauren, real quick then, what are the next steps here that we should be looking forward to?
I mean, I'm still moving to quash this because she's still, at this point seeking to get my data and the data of 42 other people. So that's where we're going with that. Jane, thank you for the 10. As a victim, I want to help you stand up for us all. Thank you very much, Jane. I appreciate you. I'm going to be working on that. Hopefully, I will have it out probably at the end of the week. I know that normally, lawyers and stuff, they'll wait till the last minute to file. But as a pro se in this court, at least, I don't really have that privilege because if I do it wrong, it takes a couple days for this stuff to process anyways. But if I do it wrong and if I get the format wrong or I do something wrong and I don't include something, then it gets pushed back. And then it's like I missed the deadline, So I'm probably going to do it by the end of the week, even though I have until next Monday. So we'll see. But yeah. Wait, Sally C, thank you for the $50 super sticker. That's so nice. Thank you so much. I don't even know, I don't even know what to say. That's just so nice. Thank you. I appreciate you. All right. Let me move that real quick. Omar said one can call and ask what you're looking for, have it withdrawn and or ask for offer of proof. I did that. So I did that not in phone call, in email. Because I'm like, if you don't tell me what we're talking about, I don't really want to call you right now because I might be like, and also I've seen what happened when Andy called, so I'm not going to do that. Right. Yeah. But I asked for those things.
Also, who wants to make a phone call? Like nobody Gen X and younger wants to get on the phone and make a phone call. Give me a break. Yeah.
Right. All right, guys. Well, that is I think that's enough for me tonight. Let me see if I missed any recent chats that we should. You can object without moving to quash. I'm moving to quash. Fuck that. Quash that shit. I mean, it's unnecessary. It's unreasonable. Nobody should be able to violate anyone's privacy like that. So
I mean, if you're not even on any of these lists, and there's no evidence that they communicated with you in any significant sort of suspicious way, why would they need to execute the subpoena? It makes no sense.
The only time I've ever communicated with anyone in the publicist or lawyer realm in this situation, I reached out to Brian Friedman for comment twice this entire time, and he did not answer. So I was like, thanks for leaving me on red, I guess.
I mean,
but like, if I was ever named in anything,
we're
it's
busy.
because I reached out to Brian Friedman. He did not respond, and it's not going to be the publicist because I never reached out to the publicist at all whatsoever.
That's nobody in this Wayfarer, and that's nobody in this tag, right? That's he's an attorney. So that's not even relevant.
Yeah. God, that's just so nutty.
Yeah.
All right.
Yeah,
everybody.
Yeah.
Go ahead.
There you go. Anyway, we're done.
Right. I'm gonna take off for tonight, guys. I'm gonna go to bed because it's 11:30. I can still get like 9 hours of sleep, which is crazy. So, no, 8 hours. 8 hours is good though. It's more than you.
Yeah.
All right.
Some rest.
Thanks everyone for joining us, and thank you, Bruce, for helping us out tonight. I appreciate it.
Anytime.
Yeah. Oh, wait. Hang on. Let me do this real quick.
What's going on? Secret love?
Nope. Shut up, phone. Shut up.
Oh,
okay.
Are we turning on?
I'm just trying to link to Bruce's channel. Guys, go subscribe to Bruce. I'm putting it in the live chat right now. Bruce's channel, Bruce from Oregon. Go subscribe. Listen to his video that he put out. Was it last night or the night before? I'm not sure, but
something like that. I've got 2 videos on this case. Whoa.
Yeah. Anyways, go subscribe to my friend Bruce here.
I'm gonna get subpoenaed for my 2 videos.
Pin that in the chat. All right. Thanks, everyone. I'll see you later. Oh, wait.
Thanks, guys.
Lottie, thank you for the 10. Lauren, I hope you don't get too worked up. You're not alone. Just think about beating Omar in another competition. Well, hopefully it won't be a fist fighting competition. But yeah, thank you, Lottie. I appreciate you. And we got one more. Don't fuck with justice. Thank you for the 5. Subpoena Gate makes me sick. I even got attacked for trying to help with it today. The Garden Variety Bar complains to serve Garden Variety Bar complaints. Hey, I agree. Listen, don't go too hard against people on the internet. Just, mess with them a little bit if you want to have some fun. But otherwise, just block and move on. That's what I'm doing these days. So unless it's David Gingras, I'll fight David Gingras till the day that I die because I don't like how he talked about Rachel. So fuck him.
What a troublemaker.
Seriously. All right. Bye, everyone. Appreciate it.
Thanks, guys.